Hello, I am Aylin Larson, and I am covering the SK case. Maryland Court of Appeals holds minor criminally liable as distributor of child pornography for sexting. In this case, my client, who is going to be referred to as SK, was 16 at the time, and she was playing a game with two other peers who were also 16 and 17, which is the legal age of consent within Maryland. And they were playing a game to see who was cooler or could go further in the case of sexting or causing or doing sexual actions and stuff. So they had a group chat, they would send sex to each other, they would send photos, and they would send videos. In which case, my client, SK, sent a video of her performing a sexual act with another minor in order to win the challenge. She had also been pressured to do this by the other two peers and was doing it to gain popularity, which most people in her situation would, because that's kind of what society is nowadays with our generation of minors and everything. And so what ended up happening is the group had a falling out. The other two minors that were participating decided to take my client's video and share it all over the school that they were attending in Maryland. And what ended up happening is my client went to a school officer in order to have either a meeting with the peers or get the video taken down so less people were viewing it and damaging my client's reputation and her mental health. Instead of being treated as a person and being given shelter and protection, the officer degraded her, slut-shamed her, and decided that he was going to have the school press charges on her for distributing child pornography. My client was not the one distributing child pornography. The peers who had a hold of her video had decided to distribute it in order to seek revenge, which is a very clear case of revenge distribution of pornography, which is a crime. My client did not do anything wrong in the fact of sending those videos, sex, and photos to her peers because A, they were not disturbed by it, B, they didn't enact on showing anybody, either an adult or anything else. They showed their school in order to harm my client. If the peers had had any issue with the video, they would have gone through and talked to either an adult, their parent, or an officer to address the situation. But instead, they spread it around the school in order to cause hate and bullying for my client. My client was charged with filming a minor engaging in sexual contact, distributing child pornography, and displaying an obscene object to a minor. When in fact, she was in a consensual conversation with her buddies. It was a game. It was not to be perverse. It was not to be maleficent. It was not in any way context the way that the school and the officer had decided to display it. My client was the one being hurt in this because she was having all of the rebounds and damages happening to her because she was being bullied from her entire school. Her reputation was going down the drain, and she was dealing with slut shaming, victim shaming, when she was just trying to be helped by those that she thought would help her, in which case was not correct. In conclusion, my client was completely misjudged and should not be facing any of the charges that she is facing currently. If this case is being brought to eradicate child pornography and strike fear into those that do child pornography, they're going about it the wrong way. Because instead of punishing those that should be punished, they're punishing the victim in this case. And this is going to make it to where all the other victims that are dealing with this or having their porn being distributed or being pressured into doing porn are not going to come forward because they're going to feel like they are going to be punished for coming forward and speaking about it. So instead of charging my client with all these charges, they need to go back and look at all the peers that did this and charge them instead. Again, she was looking for help because she was being bullied, and her video that she had made, a very private video that she had sought to not ever be brought out to public, was being brought out to public in order to diminish her reputation and just to hurt her in general. So in this case, my client should not be charged on any of the 3 accounts, and instead the trial should stop completely. My client is non-guilty, and instead the court, the school, and the school officer need to go back and look at the peers and figure out what they need to do in order to charge those individuals. Thanks. I'm Aowen Larson, and I am the defendant attorney of my client, SK.